Thank you.
SJC-11299, Galiastro versus Mortgage Electronic Registration Systems.
Good morning.
Please hold. All right, let's begin.
We got a temporary stay for a second there. Good morning. Glenn F. Russell, May it please the Court, Glenn F. Russell Jr. on behalf of the appellants Anne-Marie Galiastro and Joseph Galiastro. The issues before the Court today are primarily whether the entity known as Mortgage Electronic Registration Systems had the authority to initiate the non-judicial foreclosure process under GLC 244-14. And there's issues off of that, but the second primary issue is whether or not the defendants circumvented the injunction regarding Fremont-originated loans, and that also extends to the foreclosure law firm that was bringing the action, initiated the foreclosure process.
And you're suggesting this loan fell within the group that was governed by the injunction?
It did, Your Honor. It was a
How did it do that?
It was a Fremont-originated loan, and the opinion, Justice Gantz would clearly, if I'm mistaken, please correct me, would be better served to elucidate. But my reading of the case or the ruling stated that any Fremont-originated loan, whether or not it was subsequently assigned, the protocol was to contact the Attorney General prior to initiating the foreclosure process in general. And the evidence in this case indicates that the foreclosure was initiated through the mandatory notice of sale, which under our statutes is the beginning of the foreclosure process. That started on March 1st, 2010. Subsequently, in the judicial proceedings, a document was produced from the defendants stating that they'd only recently obtained permission from the Attorney General to go forward, and that's some 7 months post initiation of the foreclosure process.
Could you, which it may not affect that issue, but at least I think I understand that your clients, that the mortgage was transferred to Deutsche Bank and there was a foreclosure? Is that correct?
That is correct, Justice Botsford. Subsequent to the action being on appeal for 7 months, and part of the problem from the Galiastro's perspective is this case represents a distinction from the other foreclosure cases that have been before this court in that they tried to work out a resolution with the mortgage servicer. They tried, and then they brought in an injunction. I believe this is the first case before this court that they've actually attempted to stop the foreclosure. Once that, the Worcester Superior Court ruled against them without memorandum, as noted, the Galiastros timely filed their appeal. So it was on appeal for 7 months. The Galiastros, and also unlike my other, I've had 2 cases before this court on this issue, the Galiastros were paying me. They didn't have much discretionary funds. They paid me to print, bind, deliver the required amount of copies of the brief to this court. 7 months subsequent to that, there was an assignment to Deutsche Bank as trustee for the Fremont Home Loan Trust 2006-3. Part of the problem that I hope that people look at this case is this highlights the real problems with the non-judicial foreclosure process. It is an anachronistic vestige of the past that needs to be put away, but I understand that's beyond this court.
Given that, and I appreciate what you're saying, but what's still at stake for your clients right now?
Are you discussing the mootness issue?
Yes, yes.
From the Galiastro's perspective, no matter what happens subsequent, it cannot alleviate the issues related to the Fremont issue as an initial matter from the Galiastro's perspective. Secondly,
Vis-a-vis Harmon Law Firm?
and MERS, correct. And secondly, due to the assertions of the defendants in this matter, they state that the loan was transferred shortly after origination to the precise Deutsche Bank trust that ultimately foreclosed and evicted them. So the argument is that it is one continuing action. With regards to MERS, would you care to, did I answer that further, Justice?
No,
Butler?
I don't want to take your time. I've
Well,
just, okay.
I'm trying to sort out, let's assume this appeal goes as well as it can for you, and you return to the trial court. You're not seeking injunctive relief, I assume, correct?
At this point, correct.
Okay, so you're now left with money damages, and what is your money damage claim?
Would be everything that's flowed from the, if in fact that MERS, Mortgage Electronic Registration Systems, could not have initiated the foreclosure process. There's been no evidentiary documents proving that they are a proper party under statute. If it is returned and ultimately decided that in fact this was not a proper party under statute, that animates many of the attendant claims for these
Well,
people.
specifically though, what do you get? I mean, pragmatically, let's assume you go back and what do you mean? Is it money damages? You're claiming attorney's fees? I'm just trying to figure out what you say is still alive if you prevail here.
There would be money damages, Your Honor, and
Money
additionally...
damages
For what?
For attorney's fees or for something else? What would you be, what's the claim here?
For the deceptive acts under the 93A claim. The deceptive acts...
Right, but that's you'd still have to get damages arguably trebled, but I'm still trying to figure out what you would say your damages are. In terms of the type, what category of damages are you contending are still alive here?
There could be numerous. Slander of title. There could be, besides attorney's fees, which are, probably north of 1,500 hours on this case. But all of the pressure that's been put on these people, it would be related to the 93A claim, Justice Gantz.
And would that also apply to the Fremont, the injunction?
That's correct,
Also,
Justice. That's correct, Justice Bosford.
I'm sorry. After the loan was when, 2006?
That's correct, Justice Cordy.
Okay, and so it was transferred to MERS, right? MERS? I mean, where did the loan and the mortgage go? Where were they in 2010?
That's the $64 million question. The statement regarding MERS is on the registry of deeds, MERS was the quote-unquote nominee, which is another issue that this court addressed in Eaton, which apparently is still an open question for Fremont.
So the mortgage was not transferred out of Fremont?
The way it was
Six.
from the plaintiff's perspective, that's correct, Justice Cordy. There was no, unlike many of these cases prior to the auction or notice of auction, there was no assignment. It was just the mortgage that was on the registry of deeds.
And it was on the registry of deeds to whom?
It was Fremont was the originator and Mortgage Electronic Registration Systems as nominee for the originating lender. And there was no subsequent assignment. It was just that MERS stated that they were the mortgagee. It says in the notice of auction that MERS is the mortgagee. Didn't say they were a nominee for Fremont, did not say they were a nominee for anybody, which implicates the subsequent assignment that happened 7 months post-filing of the appeal, where suddenly the assignment states that MERS is now acting for Fremont, its successors, and assigns.
So the assignment was made from MERS as nominee for Fremont?
That's correct, Justice Link. That was what is on the mortgage.
To Deutsche Bank?
No, the mortgage is
No,
just...
I know not on the mortgage, but when you say it was acting on behalf of Fremont, et cetera, and I thought you were saying MERS assigned that mortgage. It did assign the mortgage to somebody.
To Deutsche Bank?
Subsequent to the appeal, yes, they assigned it to the Deutsche Bank trust that ultimately foreclosed. But opposing counsel's statements have said that, in fact, In 2010, the loan wasn't with Fremont. The loan was transferred shortly after origination to the identical trust that ultimately foreclosed and evicted them. So from the Galiastro's perspective, the determination of what the connotation of the term nominee in a mortgage context was critical as a first instance to determine what exactly that is. And if it is the agency relationship, therefore, mortgage electronic registration systems would have been acting for the same entity that foreclosed. So it is one entity, it's the same line of events.
Could you, I'm sorry to be so dense, but when was it that you say that Counsel for MERS said that upon origination, there was a transfer? When was this said?
I believe it's in the appellee opening brief. It is in the motion to dismiss the appeal, and is in also, I believe, in the current. I don't want to misspeak.
These are representations in court papers that the transfer to Deutsche Bank was made upon origination in 2006?
There's references that it was made to a securitized trust, and then subsequent that was fleshed out and stated that it was the same Deutsche Bank trust.
And that's not the same thing as Fremont, the Fremont Trust?
That's correct. Well, it is, no, Fremont is the trust. Deutsche Bank is the trustee that is acting for that entity.
Could you,
Deutsche Bank is acting for Fremont?
Is acting for that particular trust as a trustee. It's a common law trust that pools mortgages, and then the bank is not acting with its own monies at stake. In theory, it is acting as a trustee for the investment trust.
Now, if I can turn you to the Eaton issue. Eaton is perspective, except as to except as to the Eatons themselves, and you're saying, no, it should also apply to us because of what? Because it's on appeal? Because it was being adjudicated? What are you saying? If we open Eaton up to you, what are we opening it up to?
Well, in a very appropriate question, Justice Gantz. In this particular case, it is not the typical case where there was another case on appeal. This appeal was filed approximately 6 months prior to the Eaton appeal, I believe. And if I'm mistaken on that, I correct myself, but I believe that it was. Secondly, the appeals court specifically stayed this matter so that the Eaton case could be heard. It is due to the fact that it was stayed, potentially, that the Eaton case was decided prior to this case. That's his initial idea. Secondly, I know the opposition talked about a pipeline doctrine, which is prevalent in the United States Supreme Court cases. Apparently, there is no case law in this Commonwealth addressing that. To my knowledge, you folks may find differently. But if there was, this is a case that is, I can't imagine a better case for that.
But I'm trying to ask you to articulate what pipeline doctrine you're asking us to adopt. That those which are in the pipeline, meaning pending appeal, those which are in the pipeline, meaning have matters before a trial court adjudicating this issue. What is the extent of this pipeline?
I mean, in the supplemental brief, the appellants stated that, respectfully stated, that from their perspective, that initially that there should have been no prospective ruling. From their perspective, it was very easily gleaned from a case law review.
okay, but that's water under the dam.
And that would be the first argument, and I've made that argument for 5 years. And
But I take it the most narrow view that you would need to take if you accept Eaton is cases that were pending on appeal when Eaton was decided. Is that right?
That my next fallback, correct, Justice Botsford. And in particular, in this case, the fact that it was stayed, it was actually stayed by the appeals court. And if I would have taken this up on direct appellate review earlier, maybe we'd be talking about the Galiastro case instead of the Eaton case. But there were many reasons why that happened, and many personal reasons that I don't want to bore this court with. But it was and for the Galiastros as well. Well, one of the key things that I was hoping to discuss here today is the fact that it is commonly said in these cases that MERS can act for the lender, its successors, and assigns, but it is never actually looked at deeply in that they can only act for a finite group, purportedly, a finite group of MERS member note holders. That discussion is never argued. It's just a blanket, you know, it's the lender, and they can go for the lender's successors and assigns, but their own rules state that there has to be a symbiotic relationship with a note holder.
Counsel, your time is up. We'll have to leave it there.
Thank you very much. Thank you.
Good morning, Bobby Broach and Morgan Lewis and Bacchius on behalf of Appellee Mortgage Electronic Registration Systems, Inc., or MERS. And I understand appellees have 15 minutes, of which MERS has been allotted 10, and Harmon Law Group 5. I would begin by urging this court to dismiss this appeal because it is moot. The lien below has been extinguished. MERS is not, it cannot foreclose. That foreclosure has already been done. The property has been sold pursuant to Deutsche Bank's notice of sale. That mortgage was assigned by MERS to Deutsche Bank in September of 2011. Subsequently, Deutsche Bank then issued a notice of sale and foreclosed. And indeed, the Galiastros attempted to stop the Deutsche Bank foreclosure and went to the appellate court, asked for a stay. The appellate court mentioned that it was premature, so it returned to the Superior Court. When it went to the Superior Court, the court there looked at Deutsche Bank as a foreclosing entity under Eaton and found under Eaton that Deutsche Bank was a proper mortgagee under Section 14 because Deutsche Bank both held the note and held the mortgage and literally concluded that there was unity of title under Eaton, even though that ruling was, I don't know, some 4 months before this court announced its decision in Eaton.
Now, your brother says, well, that, he doesn't say it in these words, but essentially, let's assume that that subsequent foreclosure accords with Eaton, but the initial notice of foreclosure that MERS did was improper. He claims they did not have standing, and he claims, well, that caused my client to incur costs. That's best I can ascertain, the cost being his attorney's fees. Why is that not still a damage claim, that there's still an attorney's fees claim based on what he contends to be a wrongful notice of foreclosure by entity which had no right to foreclose?
Two things, one substantive and one procedurally. Procedurally, below, what the complaint alleges is to try to stop the foreclosure sale pursuant to the March 1st, 2010 notice for a sale that was going to take place on March 31st.
Does it have a general prayer for relief? Any other relief you think is good news?
I don't think so. It's a 5-count complaint, and indeed the 93A claim and the civil conspiracy claim relate to damages for the Fremont injunction. So this is apart from the violation of the Fremont injunction, but I believe the essence of the complaint is really, when it comes to MERS and its standing, was to enjoin the sale, stop the sale, because MERS didn't have the proper standing.
Right, but
Now, substantively,
speaking to Justice Botsford's point, page A10, plaintiffs respectfully demand equitable and monetary relief as follows. B, a judgment in their favor awarding damages from the defendant together with interest on each applicable count. And C, judgment awarding the Galiastros their costs and expenses, including reasonable attorney's fees. So it is there in the general relief.
fair enough. And that's what I would say to the substantive point, and that is whether MERS did have the standing, quote unquote, or the right as a Section 14 mortgagee to give that notice of sale on March 1st, which indeed it did. Remember, of course, March 1st, 2010 is prior to Eaton, and the common interpretation then that was being utilized of the Section 14 mortgagee was if you held the mortgage.
Well, you're sort of gliding over whether as nominee gives you the right. I mean, but substantively, one would need to reach those questions and decide them in your favor, which doesn't argue for mootness, does it?
Well, what argues for mootness is the fact that the foreclosure sale that went forward didn't go forward to MERS exercising its power of sale. So that's what makes it moot. As to whether it's material at all, whether MERS had the standing to initiate that foreclosure with that notice of sale. And I'm not sure what damages would incur when you give a notice of sale and the sale does not go forward. But at the time, MERS was the holder of the mortgagee, and as I will address, as the nominee for the lender and any of the lenders and lenders assigns. And what that means, nominee, by definition and as adopted by some Massachusetts federal and state and bankruptcy courts, is a nominee is a person designated to stand in the place of another, literally to hold the legal title for the benefit of the other. And the face of the mortgage itself states just that MERS is designated as the mortgagee to, instead of the lender and the lender's successors and assigns, to hold that legal title to the mortgage and hold the legal title to the mortgage. And that's exactly what MERS does. And of course, in the Commonwealth, the idea that one entity can hold bare legal title to the mortgage for the benefit of another is well accepted in Eaton and Ibanez and even before. And that's what MERS does. It holds the legal title for the benefit of that lender or note holder and any of its successors and assigns.
Now, not all courts have agreed with that proposition, right? I mean, Oregon and Washington, they have taken a different view of whether the security instrument standing alone authorizes MERS to foreclose as a nominee, as an agent.
I mean, that actually raises another point. Are you going to talk about what, besides nominee, makes this an agency relationship, other than the bare document itself, which seems to suggest but doesn't quite say, and what is the other support for who's the principal that authorized the agency relationship to exist?
Okay.
It's related, but you can answer
So you
Mrs.
have
Lynn
two
first.
questions in front. Yes.
Didn't want to lose my chance.
I will
Right
address that.
ahead.
In answer to your question about Washington, Oregon, those are under specific statutes of that state as to what the word, actually not mortgagee, but beneficiary means. And what those courts did is they looked at that state statute, deeds of trust in those states, to determine what the word beneficiary means. And in those state statutes, they define the word beneficiary and talk about holder of the security instrument. None of those issues are here in the Commonwealth, in the sense that Massachusetts has long recognized that the mortgage doesn't travel with the note, and so when the note is traveling, it is perfectly appropriate for that mortgagee who holds legal title to hold that legal title for the benefit of each note holder as that note transfers.
So now you're going to say that this is the same here because it's a mortgagee as nominee. And you're going to
mortgagee.
tell me
MERS
why, as mortgagee as nominee, is also a mortgagee as an agent who could take those, and it's not a different thing. Because I don't frankly understand what a nominee really is, unless it's an agent, and then you need to show me why.
I think a nominee is akin to an agent. I think it is a form of an agent. I think by definition, a nominee, as I said, is a person who is to stand in the place of another, which is a form of an agency.
Well,
It's a term.
Is it, what makes it different, other than it just standing in the place of, how about an actor? A nominee can stand in the place of, but what does it authorize? And who's authorizing what?
Okay, well, MERS is a membership organization,
Right.
so its members have membership agreements and terms and conditions that govern their relationship between MERS as the nominee or agent of these various members and their principals who are the members. So I think the way the structure works is that the principal in that analogy is the members of MERS, and MERS serves as their agent or their nominee by acting and serving as the mortgagee of record when the mortgage is recorded. And that MERS, as that nominee or agent, takes its direction from the members, first and foremost from the holder of the note, the member who holds the note, when they're transferring the mortgages or initiating foreclosures. So when foreclosures are initiated, when they are initiated by MERS, that's at the instruction of the member who is holding the note.
Is that an evidentiary matter?
It could be an evidentiary matter. That could be an evidentiary matter. In other words, if you concluded that Eaton applied retroactively, and you conclude, which it doesn't, but if you did conclude that, then I assume this court would remand back to the Superior Court for a determination as to whether at the time of the March 1st, 2010 sale, MERS was authorized by its principal, who would have been the note holder, who I believe in this instance would have been Deutsche Bank.
Okay.
In other words,
Right.
They didn't do it at the time because this was pre-Eaton. There was no requirement or necessity to determine whether MERS was acting under the authority of the note holder, because it was relying on the law at that time that to initiate a foreclosure under Section 14, it simply needed to be the holder of the mortgage, the mortgagee, with the power of sale. I should make sure I emphasize that the mortgage itself grants to MERS, not to the principal or the note holder. It grants to MERS specifically that power of sale.
Counsel,
So-
I have to interrupt you. Your time is up.
Okay, thank you very much.
Good morning, Your Honors. May it please the Court, my name is Attorney Natalie Salomon, and I am counsel for Harmon Law Offices. The judgment of dismissal granted in favor of Harmon should be affirmed for two simple reasons. Harmon did nothing wrong, and what it did, which was simply file a complaint on behalf of its client, is protected by the litigation privilege. I would also ask this Court to award Harmon its appellate fees, because this case is clearly a frivolous action. And while I understand that courts are reluctant to allow fees of this sort, and we do not have any animosity against Attorney Russell, it's clear that in this case there was absolutely no need and no valid reason for the Galiastros to involve Harmon in their dispute against the bank. It's essentially, this case is nothing but a baseless lawsuit assault against attorneys who do unpopular work, such as foreclosure sales. And it is incumbent upon this court to put an end to this abusive practice and to enforce the litigation privilege vigorously, and also to award fees so that we can avoid any proliferation of abusive lawsuits against foreclosure firms.
Now, you said that your firm was involved in the filing of a complaint. What complaint?
The SCRA complaint, Your Honor, the Service Members Civil Relief Act complaint.
That complaint.
Which is not part of the foreclosure proceeding, as this court recognized in the Matt case. It's a separate and judicial action brought to ensure that the mortgagor is not entitled to the benefits of the act.
Okay, but let's put that aside, and let's assume that the plaintiff says, okay, I'm not challenging your involvement in that. I'm challenging your involvement in the filing of the notice of foreclosure, which was not a complaint, but a notice. So you're saying the litigation privilege would apply to that as well?
Yes, Your Honor, because a foreclosure process is essentially a continuum of actual and potential litigation. So as aside from the foreclosure and along with the foreclosure process, which involves sending notices of foreclosure and publishing notices of foreclosure sale, you also have that litigation part, which is filing the SCRA complaint. Now, during the course of a foreclosure proceeding, a bank sometimes has to defend itself in a litigation involving a request for an injunction, as was this case in here. Once a foreclosure sale is conducted, and if the bank takes title to the property, then you have a litigation, the summary process action to evict the mortgagors. You can also have a deficiency action to the extent that anything is owed after the foreclosure sale is conducted, and if the sale itself was insufficient to pay off the debt of the bank. So in other words, the foreclosure process, the life of a foreclosure proceeding involves litigation, either actual or potential to some extent.
Well, how far do you extend that doctrine? Okay, let's take a case, which I don't suggest is this one, in which the attorney knows full well that there is no lawful authority for someone to seek to foreclose, and they provide legal cover for that person and aid and abet that person to do a foreclosure which they know is totally without legal authority. Is there any situation where you say the attorney may be liable for that?
For a situation in, so in the example you gave, Your Honor, if the law firm knows very well that a complete different entity is
Let's assume that they,
is
let's
entitled
let's take the worst case. Let's assume they know it's a fraud. Let's assume that they know that some company is trying to basically steal the property through a false foreclosure. Take the worst possible scenario. Are you saying that the litigation privilege would protect an attorney who knew of that fraud and participated in it from any liability?
Well, I think in this case, it would not be, any action undertaken by the law firm would not be taken under any good faith. So maybe in a matter of if there's not a good faith representation of the bank by the law firm, maybe in that case that would apply. But here in the conspiracy theory, I would say the conspiracy claim was properly dismissed because there's absolutely no plausible allegation that Harmon agreed with MERS to do an unlawful act, and that when they did it, they knew that it was unlawful. But to answer your question, I think we have cases not from this court, but from the First Circuit. And I believe that this case, no, it was from the Federal District Court, United States versus Rockland, where it involved an interpleader action, and the plaintiff was holding surplus funds after foreclosure proceeding. A couple of defendants claimed to be entitled to the surplus funds, and the attorney of one of them filed a paper saying that everybody else, all the other defendants have been satisfied. They do not have a lien ahead of my client's lien, and therefore my client is entitled to the entirety of the surplus funds. And it turned out that this was incorrect. And the court found that the litigation privilege still applied. Whether or not Rule 11 should be enforced is another question for that case that the court considered. But in that situation, even when, in fact, the allegation being made was incorrect, the court applied the litigation privilege.
Counsel, we have to leave it there. Thank you.
Thank you.
Thank you.
Say more. It would help if you if they're going to split the times, 10 minutes, 5 minutes, that kind of thing. Thank you.